Why are you standing?
Yeah. Yeah.
First of the issues that we are considering is the competing arguments on the options available to the governor under Article 200 and 201. The submission made on behalf of the Union of India and of some of the states that have supported the reference is that the text of Article 200 is explicit. Upon presentation of the bill, the governor can assent to the bill. Upon presentation of the bill, the governor can assent to the bill, or he can withhold assent therefrom, or he can reserve the bill for the consideration of the President. The first proviso to Article 200 regarding return of a bill to the legislature according to this submission is an additional option available to the governor, making it a total 4 alternatives that the governor can choose from. Then they have placed reliance on the various judgments. In opposition, it has been argued that Article 200 provides the governor with 3 options only: assent to the bill, reserve it for consideration of the President, or return the bill with message to the House requesting it to reconsider the bill or a part of it. And after such reconsideration, if the House passes the bill, again with or without amendment, the governor is bound to give assent. And they have placed reliance on the various judgments of what of the state submission. The second interpretive choice on Article 200 is to bind the first proviso to the substantive part of Article 200, to qualify the power of the governor to withhold the bill, in which case the governor is provided with a total of 3 options between the substantive part of Article 200 and the first proviso thereto. First, the governor may assent to the bill. Second, he may reserve the bill for the consideration of the President. Third, he may withhold assent therefrom and return the bill to the legislature with comments. And if it is passed with or without amendment, he shall not withhold the assent therefrom. The third option, in such a reading of Article 200, can be exercised only if the bill is not a monetary bill. The substantive part of Article 200 employs 3 verbs that indicate the options of the governor: assent, withhold, and reserve. Each of these actions are qualitatively different from one another. However, the first proviso, which repeats the verb withhold, indicates that the word withholds in the substantive part is not without qualification. The first proviso, in our considered opinion, qualifies the verb withholds in the substantive part and obliges the governor to return the bill in accordance with the first proviso, except in case of a money bill. In that sense, the first proviso is not an exception that creates a fourth option. It is rather qualification to the substantive part of Article 200, limiting the full play of the word withhold employed therein. There is a firm opinion that if 2 interpretations are possible, then an interpretation that favors a dialogic process that encourages institutional committee and deliberations between the constitutional institutions. In this case, that of the governor and the House or the Houses must be preferred over an interpretation that limits or excludes such a dialogue. Such an interpretation prevents institutional redundancy. Whatever the description of Indian federalism, we think that it would be against the principle of federalism, a derogation of the powers of the state legislature to permit the governor to withhold a bill without following the dialogic process in the first legislature to Article 2 permit the governor to withhold a bill, in our opinion, without following the dialogic first proviso, initiating a constitutional conversation between the institution of the governor and the House or Houses, and the option to reserve the bill for the consideration of the President under the substantive part of Article 200 exemplify the cooperative spirit of Indian Constitution and also bring out different facets of the checks and balances model that the Constitution has envisaged. A dialogic process which has the potential to understand and reflect on conflicting or opposing perspectives to reconcile and to move forward in a constructive manner is an equally potent check and balance system that the Constitution has prescribed. Once this perspective is grasped, the persons who occupy various constitutional offices or institutions will also do well to ingrain in themselves that dialogue, reconciliation, and balance, and not obstructionism is the essence of the constitutionalism that we practice in this republic. The next issue we are considering is whether the governor is bound by the aid and advice rendered by the Council of Ministers while exercising all the options available with him when a bill is presented before him under Article 200 of the Constitution. Before we opine on these aspects, on whether the governor is bound by the aid and advice of the Council of Ministers in exercise of his functions under Article 200, it is relevant to note the judgment of this court that have taken a view of the discretion of the governor and Article 200. Particularly, both sides rely on the same judgments, but offer different readings or interpretations of them. Like Shamsher Singh versus State of Punjab, then MP Special Police Establishment versus State of MP, Nabam Rebia and Bakmang Felix versus Speaker, Deputy Speaker of Arunachal Pradesh Assembly. We are of the opinion that from the above discussion, the following position of law clearly emerges. First, ordinarily the governor exercises his functions in accordance with the aid and advice tendered by the Council of Ministers. Secondly, the Constitution itself provides that the governor may discharge certain functions upon his discretion and without being bound by the aid and advice tendered by the Council of Ministers. Thirdly, the circumstances or occasions where the governor is to discharge his functions without being bound by the aid and advice of the Council of Ministers are either expressly provided or through necessary implication, where the constitutional context requires exercise of this discretion. Such a context, the role of the President in protecting and defending the Constitution is binding the Union as a cohesive unit is crucial. It is reiterated that the President will be unable to exercise his functions until the Governor a priori reserves a bill for his assent. It is unlikely that the Council of Ministers, without whose support the bill could not have been passed by the legislature, will advise the Governor to return a bill to the legislature or refer it to the President under Article 200, thus frustrating the operation of numerous provisions of this Constitution, including the President's powers. In such a scenario, it is unfathomable to hold that the Governor is not conferred with discretion under Article 200. We are also of the considered opinion that the inclusion of the phrase "in the opinion of the Governor" in the second proviso to Article 200 is but a definitive expression of the fact that Governor does enjoy his discretion in discharging his functions under Article 200. Either the Governor enjoys discretion or he does not. There is no interpretive space for discretion while exercising some options of Article 200 and no discretion in others. A limited application of this phrase to only the second proviso is neither logical nor in accord with the constitutional scheme. We find it difficult to agree with the submissions canvassed by the parties opposing the reference that a limited interpretation must be placed on the opposite phrase. This second proviso is clearly a qualification or a condition of, and not an exception to the exercise of discretion contemplated under substantive part of Article 200. We are conscious that a government run within the four corners of a written constitution must be responsible. Having already held that the Governor does not have powers simpliciter to withhold, we find that the Governor has discretion in the context of referring a bill for the consideration of the President or for returning the bill to the legislature with comments. We do not think that the interpretation confers any unfettered powers on the Governor. In fact, it does not in any way deviate from the concept of a responsible constitutional government. Much has been argued on the role of the Governor and the President and the cabinet form of governance that parliamentary democracy consists of by parties opposing the reference. They argue that this system of governance abhors conferral of discretion on the governor. We are in agreement that it is the elected government, the cabinet, that should be in the driver's seat, and that there cannot be two executive powers centers in the state, as held in Ram Jawai Kapoor and others. However, we find that these arguments relegating the governor and the president to a perfunctory role that is merely the formal head, comparable to the crown in England, oversimplifies the complex scheme of our written constitution. The constitutional vision is of a responsible government, which is not merely synonymous with the cabinet, but is also one where the governors and the president have been bound by specific functions and roles in the written constitution, unlike the crown. We clarify, as we already held, that the governor has no option to withhold a bill simpliciter. Therefore, it is not that the discretion so conferred allows a situation wherein the governor could frustrate a bill in perpetuity. The three clear options that he has is to grant assent, withhold assent, and return the bill to the legislature for reconsideration, or reserve the bill. For choosing any of these three options, having given due regard to the aid and advice rendered by the Council of Ministers, and keeping in mind his duty to protect and defend the Constitution. The next we consider questions number 5, 7, 10, and 11 relating to the discussion of time limits on the governor and the president for exercising their discretion under Article 200 and 201, and the issue of deemed assent. The text of Article 200 and 201 has been framed in such a manner so as to provide a sense of elasticity for constitutional authorities to perform their functions, keeping in mind the diverse contexts and situations